All right. Good evening, everyone. Welcome to our YouTube live session. Today on the panel, we have Advocate Ayush Negi, who is an advocate on record, Supreme Court of India. And today we are discussing how to conduct yourself in the courtroom or how to speak to a judge. Because always when we watch the TV shows, we are always fascinated by how Harvey Specter speaks up. But is that the reality? We'll find that out today. We have a lot of questions piled up that Mr. Negi will answer for us. So let's get started. Over to you, Mr. Negi.
Thank you, Rudresh. So all this has been basically we all have started our journey together on this. Like advocates, we all have the same journey. So we start and initially we don't know what to do when we pass out from because the college is a totally different atmosphere. And when we do our moot courts and everything, I understand there we get to know, but those practices are something different, which is followed in court. So the court procedure and the court practice and etiquettes are totally different, which to my knowledge and to understanding nobody tells us. You join the office, you see your senior, how he behaves, what what he how he talks. So it is all observing and seeing and learning. So there is nothing, there is no classes or not a finishing school for this where you can actually go and learn as to how to conduct yourself. So this is my endeavor to try and tell you or at least guide you to how to go about it in court. So first and the foremost, I would start with how to dress appropriately. See, we all know what is the dress of court. The court dress is also, if going by the law, the Bar Council rules, the Advocates Act provides for the dress, which is black coat, white pant, and similarly kurtis and this thing for girls. It is there provided. But for boys, it is provided that you can wear grey pants. But there are certain shades of pants which are provided. That is all you can wear. Not unlike what I have seen in my experience in some trial courts and sometimes in some areas, backward areas where this thing you see lawyers wearing jeans. I have seen lawyers wearing sports shoes, which is which is see nobody objects to it, but at times the judge can say that this is not the proper dress code, and I have seen trial court judges telling that this is not proper. You have to wear a coat. You have to wear in trial courts you can wear a tie, and in the High Court and Supreme Court you have to wear the gowns and the band, advocate band. And in other courts I've seen sometimes people wearing just the Nehru jacket or the waistcoat only, and with their bands up, and all kinds of this thing. That is something we should avoid. See, your first impression is when you stand in the court. When you're not dressed properly, so it is highly likely that the judge will not take you serious, or even he might deny to hear you, saying that you're not dressed properly. So that is something very important which young lawyers need to learn. For girls, I would say there is a separate dress code which is provided in the shades of black and this thing. But at times I see, even in the higher courts, I see that at times girls carry a very flashy bag. That you should not do. A carry bag, maybe if you're going to court, you're carrying your stuff. It's all right. You carry your stuff. Either you keep the bag somewhere, or it should be not very colorful or not very flashy. It should not be very flashy. Or at least when you are arguing in the court, you should put your bag down and then argue. I've seen girls or women argue while they have their bags up. So this is a little bit this thing which one should note, because this is I'm talking about my personal experience which I have seen in court. So we should be very careful about how we dress in court. And their Bar Council rules also provide that advocates should not wear, like when if you are driving, like if you're leaving from your house, you have to wear your pant and shirt, but you should not wear your band. That is not allowed. The Bar Council India rules say so. You should not wear your gown and this thing. You can maybe wear your coat, but you're wearing your gown and band in public is not allowed. It does not look good. It's eventually it's your dress. Like for like army have a dress. Army has a dress code. Navy has a dress code. This is our dress, and we should care for it. Like I would
All
share
right. So,
one of the Yeah, I
I
would
just
just
wanted
share
to
one.
ask. Yeah, yeah. Go ahead. Go ahead.
One small anecdote. It's very important. Then we can switch to the other thing what you want to say. In see, like in our Indian culture, we touch feet of our elders, of our seniors. So in like once we are an advocate, once we are in a dress, then we should avoid all this. Then we should avoid. Our culture is something else. We should. So this happened with me. I was in the High Court in Nainital. So I started my practice. So I met a friend of my father's. So I went to touch his feet. He said no. He said, no, beta, you are in your dress. You should respect your dress. This is your dress. This is your vardi, and you should respect it. No touching feet here in your dress. When you come to my home, come to my house, you sit, you talk. We can do and you can touch my feet. That's perfectly all right, but not in your dress. So that is also something one should note. Now we can carry forward here.
So I just had a question, following up question for this. We have several times seen petitions coming up, specifically in the Kerala High Court, that it's too hot here, we cannot wear the gowns, and there are certain objections when one sect of lawyers have been raising up. So. What are the findings in those cases, and what are the developments in those lines? If you can just throw some light on
See what happens is, see in at least in Delhi, what they do is they wave off the gown in they come up with a notification every year. Like right now in Delhi, at least in the High Court, the gowns are waved off. The Supreme Court Bar Association has been requesting, people have been making this request in this thing because it is very hot, and people have been making requests that the gown should be waved off at least in summers. I don't know that it's for the bar council and for the Supreme Court to decide and take a call on it. But yes, in on trial courts, from my experience in Faridabad, Haryana, even the courts are waived off in summers. So that is something which is there, and many other courts follow suit. They allow the advocates not to wear the gown in at least in summers till October, till it's okay. So that is there.
All right. And picking up from the heat that we have always seen that lawyers have been arguing on the salutations that we should use while addressing a judge. There's a lot of ambiguity in the media right now that how a judge should be addressed. So if you could throw some light on that too.
Yes, so see the Bar Council in 2006. Hello, am I audible? Hello,
Yes, you are audible.
Hina, am I audible? Rudesh, yeah, am I audible?
Yes, yes,
Yes.
you are audible.
So
Yeah.
see the Bar Council in 2006 they came up with a resolution, and they said that you address the High Court and appellate courts as your honor or your lordship or your lordships. Your honor or your honorable court, your honor and honorable court. They say that you give up this your lordship and your this thing, and and the trial courts you can address as sir. This is the Bar Council resolution of 2006. You can look it up. You can find it. So they wanted to give up this. This is a colonial practice, and time and again many high courts, even Chief Justice of India, former Chief Justice of India, Justice Bobde, he also mentioned this. He says either you say sir, you don't call us your lordship. There was this thing that there was a PIL filed in Supreme Court. So they said you waive off this or you pass something. So they said we can't do it. It's for your lawyers. We have nothing. You can call us whatever you want. You want to call us your lordship, you call it. You want to call your honor, you call it. So in US, the Supreme Court there they call your honor. So and in practice, see what I have seen. We call at times during the course of argument we call them sir. It's okay. They never object to it. So there was certain incident which happened. I think it was this year only. So there was this young counsel who was arguing, and he called the court. The lady judge was there, so he called the court your lordship. So the court asked him that why are you calling your lordship? Either you call ma'am or you call. He said no. And he went on to argue. This. I will come to this further. He went on to argue that no, we respect the chair, and that's why we say your lordship. So whether it's a lady or whether it's a lady or it's a man, we'll call your lordship. So there was this whole fiasco about it. That either you call it lady, you call the judge ladyship, my ladyship, or either you just call sir or ma'am, and the judges never object to it. At least some of them never object to it. It's very, this thing, it's a very, this practice that sometimes some judges mind, but at times most of the judges, they don't mind until the time you are arguing your matter and you are making sense. It does not matter what you call them. So that is about it. But that this is another limb where I would like to come to. So this is next part in how to conduct court proceedings. So you have to be, this is very important. So once you start arguing a matter, once you are in the court of law, you have to be very careful as to the mood of the court. So I would suggest that any counsel, if you're going to a new court, at times you have to travel for work. If you're going to a new court, you sit in the court, you observe how the proceedings are going on, how the judge is reacting, what is the mood of the court, and you read up about what kind of judgments he's passed. So you have to do your research. You have to sit there and observe as to how the judge wants his court to be run. Then you have to act in a particular manner. At times, what happens that people don't realize, if the judge does not like cross talking between, and one should not usually cross talk when the other person is arguing, until unless you ask the court for the liberty to do so. So otherwise, one should not do that. You should not cross argue when the other side is arguing. You should see when the judge is putting up. See what I have seen in my personal experience, that see, once you start arguing a matter, the judge puts up few queries to you. So what many times lawyers do, and sometimes even experienced lawyers do, they just jump the gun. They continue arguing their own case on their own this thing. So at times this is very annoying to the judge, and the judge actually gets very annoyed. So either you seek the leave of the court, you ask them that, my lords, I would like to come back to these points. I would first make my argument and then come back to it. So that is the right way of doing it, and not just to skip those questions. So either you answer those questions and then come back to your arguments, or you finish your arguments and then you answer. Make sure you always answer the query of the court. If you skip it, the judge will get annoyed, and see, eventually it is the judge who is going to decide. So if he forms this idea about you that you are trying to skip the queries, or you are trying to take the court for a ride, or you are trying to misguide the court or by saying something, that is another very important aspect of these arguing in the court. So once you are arguing in the court of law, you have to be very careful about the facts. So see, there is a very thin line between when you are concealing something and when you are partially opening certain fact to the court. See, the court is also, they have also been advocates. They know when the advocate is trying to hide something, or he's trying to cover certain fact. So you have to be very careful when you are arguing. You have to see if the judge is coming in, when the judge catches you on some point and you're trying to hide some point, or when he catches you, he tells you, okay, you tell me this point, yes or no. You have to answer it. You can't just say no, no, this is not there in my case. Oh no, my client has not done this. You have to concede to a certain extent. You have to say, yes, my lord, this point is there, but I will make good my case. Or I will argue and I will show how this is not affecting my case. You have to argue it like this. You can't just skip it and say, no, 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 this is not there. Just to take, then this is one thing where the court again gets annoyed. If the court is asking you a question that whether this fact is there in your case or not, or whether you are aware of this or not, if you are not aware, the court will rather appreciate if you say, my lords, I am not aware, I can get back. If my lords may put this matter tomorrow, I will research on this point, I'll get back. The court would appreciate that. Rather, you try to dodge the court and say something else or make a vague argument. So these are the things, while you are arguing in court, you should keep in mind. Then the other aspect is, once you are arguing and the other side is arguing, you have to be fair with the, and you have to be fair with the other side also. You have to give the other side also fair amount of time to argue. You argue your case, let the other side argue his points, then you take a rebuttal. You don't cross argue ever in any court, trial court, high court, supreme court, ever. You never cross argue. That is the worst thing you can do in court. And people think that, oh, that I cross argued, I did not let the other side speak. It's not a good court etiquette. It's a bad court etiquette. You should always allow the other side to speak. If you have a good case, if you have those points on merits, you will win the case. Does not matter if you cross argued or if you whatever you did. So certain times the judges get annoyed on this. So this is one, and you should then prepare your rebuttal and give your rebuttal on all the aspects, whatever the other side has covered. Should try to, and you should always try to support your arguments with the law. You should always try to, and you should always read the file properly. You should be master of the facts of your case, especially in, see, and there's a different style of arguing in trial courts. What I have seen, because I have appeared in trial courts in UP and Uttarakhand and many other states. I've appeared. What people do is, like in UP and other states trial court, it is usually in Hindi. So it is not that, oh, I know English, I will only argue in English, because English is the language used in the high courts and Supreme Court. There, if the judge is asking you certain query in Hindi, you can answer in Hindi, but usually it is always in English. But the trial courts, you have to be very sure. If you go to a outside court and you start arguing in English, you have to see the atmosphere of the court. You have to see if the judge is comfortable in Hindi or English. If everything is being done in English, then it's English. If it's in Hindi, then in Hindi. You have to modulate. You have to act in the way. And certain times, what happens is, when we go to courts, like if you go to Haryana, so there right now the courts are off. So if you wear coat, so anybody and everybody will know you are from Delhi. So you have to adopt. You have to not wear a coat. You have to dress accordingly according to the process of court, or the common culture of the court. So you have to adopt at times as a court. You have to adopt. This is the trait of a good counsel, that you adopt the court or the place where you go and the culture that you have to adopt as a counsel. So that is one thing about how to dress or how to. So trial court, when you argue, I'll just touch a little bit on this. Trial court, when you argue, you have to be very clear with the facts. The court will question you on the facts and less about the law or the provision. So you don't have to argue on sections. At times, when it comes to final arguments, you have to use your cross examination. You have to use the evidence, and then you have to put in the law, and then you have to argue like this. High courts and Supreme Court more about, because the evidence is already recorded. So facts to a certain level have already come to a certain. The judges, the courts have given a certain finding of facts. Then you have to attach law. Then when you are when you are writing a writ petition or something, you have to understand the law, or the legal, the judgments, what the legal position is, and then you have to connect the facts to the law. Then you have to place it. So in high court and Supreme Court, you have to focus more on the law and not on the facts while you are there. At times, the court will ask you about the facts. You have to, when you draft or when you argue, you have to focus more on the law. That is what the court will, most of the courts appreciate. Until unless in some kind of case there is a certain uh, different law or something very striking fact which needs to be brought to the knowledge of the court. So that is the way of arguing in high court, or high court, Supreme Court, and trial court. That is how you frame an argument. Now, another aspect I would come to now, because of framing an argument. Another aspect is, what is your demeanor is when you go. See, at times I've seen even the senior members, but does ignore. There's a very senior guy who does ignore at times. But the right way of doing is stand upright on the dais. When the court asks you a question, you have to stand. You answer sitting down. You have to stand on the dais. You you have to stand straight, not sideways, not this way. You have to look at the court. You have to maintain eye contact. It's a very spoken argument. In the debate or this thing. So you have to maintain eye contact. And that, if it's a difference or more than two judges, you have to always address the judge who is asking you the question, then answer. So look in the eye, then answer. Think, you take 2 minutes, then answer. Then you always have to keep either your hands at the side or behind.
But I think your voice is breaking a little. Uh,
Yes.
if
Now
you
I'm
could,
clear.
and is there a background noise in your office or something? We are hearing some
No,
echo.
echo. I don't know. There's no background sound here.
Yeah, we are
So
better now. Yeah, you
yeah,
can continue. Yeah.
yeah. So you have to stand upright. I was there. You have to stand upright. You have to always put your hands behind or by sideways or on the dais. You don't have to bang. You can show your aggression in your arguments. Then you have to be very sure you're not shouting. You can raise your pitch, but not to the extent. Then again, coming back, you have to be very sure that the judge is not annoyed by that. If you're raising your pitch or you're raising the pitch of your argument, you have to be very sure that the judge is not getting annoyed by that. So you have to be very sure about these facts. So then the tone you are speaking, then then it would be how you are addressing the other side. You never address the other side directly, whatever it be. You never, even if the other side is doing it, that is the right way of doing it. Even if the other side is addressing you directly or raising some kind of particular allegations or some insinuating something to you that he has not done it or this he or she has not done it, then also you don't never argue and never face him and argue. Always have to keep in mind you are arguing in the court. You have to tell the court whatever you have to say. You have to tell the court. Never address your opposite. So, and you never keep your hands in the pocket, and you never stand sideways or this way. You always have to stand straight. So this is about your body language. Because your phone should be on silent. And then another aspect is coming. I've already covered how to address the court, manner of redressal, manner of rebuttal arguments, and everything. Another very important aspect is, especially in trial courts, how to manage your client. That is another very important aspect. How do you manage your client? So in trial courts, we
How
always have how to manage your clients. Trial courts, we always have our clients by our side. So at times it happens in the heat of the moment, the client also gets excited and starts speaking. So you have to make sure that it does not happen, because that will ruin your whole case. Even if the court might be considering your case and might be in your favor, that also you have to ascertain that the court is in my favor and everything is going in my favor. So then you have to ascertain that. And then you have to always, when you come to the court, you have to make sure and tell the client, see, you keep quiet, don't speak anything till the time you are asked to. So you have to also, and even in the High Courts and Supreme Court, it does not happen usually in the High Court and Supreme Court that the client speaks till the time it is, if the court asks. But in trial court, it so happens many times. And then we lawyers have to face the brunt of it. But as a lawyer, you are responsible what your client is doing in court. So you, because eventually his case is gone, but eventually you also have an image to carry, and the judge will say, oh, every time your client is doing like this. So you have to handle your clients. So that is also your duty. Now coming to a very important aspect, another, because we are talking about to how to conduct ourselves in court. So at times in district court or in high court or supreme court, you're briefing a senior. Many times you have to, because it is the call of the brief that you have to engage the complexity of the brief. You have to engage a senior advocate. So once you are engaging the senior advocate, you also have to keep in mind that you have to let the senior talk, and the senior is going to argue the matter. You never address the court directly once the senior is arguing, until and unless the court asks you that you tell me what is there. Because see, you prepare the brief, you brief the senior, you tell him your points. That's it. You can brief this. You can prompt the senior if there is something, but you should avoid prompting very often, because the senior has a line of argument which he's doing. He will also get disturbed if he will get disturbed, and the court also sees that, okay, it looks like you are not very well prepared. So then you should not talk. You should not talk until unless you are asked to when you are briefing a senior. You should not keep prompting the senior every time. It's better you prepare the senior very well with the briefs. A day prior, you give the senior a detailed briefing, give him a brief note, tell him the facts and everything. So this is about how to this thing. And even if you are with a friend, if you are sitting with a friend or you are helping a friend in a matter, you have to be very sure that you don't keep prompting him. So it looks like that he's not prepared or your team is not prepared. Should be very sure. Even if you like even if you are going with a senior, so you can maybe pass on a slip to the senior. That is a better way of doing it. You pass on a slip, whatever your comments is or whatever suggestion is, and put it on the dice. He will see it. Rather you whisper in his ear every time and you pull him or disturb him in the arguments. What you can do is you can put it in a and give it to them, or your any other colleague. If you are co-chairing a matter with your colleague, you do this. You put it in and give it to your colleague. He will read it and you will use it in the arguments. So this is how to conduct yourself in courts with regard to how to dress up, how to argue, how to use what kind of salutations. Basic court. These are very basic court etiquettes. And see, nobody teaches us. All of us have learned this seeing each other or seeing our seniors in court. So this is, I think, very important. Now I've covered how to brief a senior, and now important aspect is I will just briefly touch it because this is a different topic altogether. Essentials of pleading. There are certain important aspects like essentials of pleading. So pleading means you're drafting, whatever you're drafting. So first, as I told earlier, there's a very thin line between what is concealment, what is not concealment. There are judgments to this regard. So once you are drafting any like in plaints, you have to be very sure you are not quoting any sections. You are not quoting any law, any judgment. You don't have to. So that's a basic bar that you don't plead the law. So you just put in the relevant facts, and then you have to decide what is a relevant fact in that case, what is not relevant. And at times, like in High Court and Supreme Court, what you do there, you can quote the sections, you can quote, but you should avoid, and your drafting should be very crisp. Though at times people differ. Some people love to make it voluminous or to show the client that, oh, we have worked very hard. See, we have put in 500 pages of pleading. So that, according to me, that is my style of drafting. I try to make it very crisp. All the points should be there. The relevant sections, if it's necessary, if it is very complicated or about interpretation, the necessary section should be there, or the relevant judgment should be put in the synopsis or wherever it is important. So all that should be there. So what happens is, like in High Court, this is very important. Like in High Court, if there is a communication between your client and the other side, and there is certain particular line in the letter which is going against you, which can destroy your case. So what we do is we mention that letter, we mention the content, but we don't annex it. So it is in between concealment and what is not concealment. So you've mentioned the letter, so you come out of concealment of fact, but you've not placed it on record. So these are certain drafting skills which you use, where you can uh, come in between. Somewhere you would lie somewhere in between concealment and non-concealment. So that is one thing. And courts are, even if you have a very good case, if you commit a small mistake of concealing a small, very tiny fact also, and court can take it otherwise, and it can destroy your entire case. So you have to be very particular about that. Then another aspect, recently Supreme Court commented on this, that somebody cited a overruled judgment. So that is, again, it's considered as a sin, that he cited an overruled judgment. He did not know the correct position of law. Then the Supreme Court said that this is not the right way. So you should always try to. You are an officer of the court. You should always try to assist the court in the right manner. The court would take it that you are trying to misguide the court by citing a overruled judgment which is in your favor, and the law has changed. So the court takes it that you are trying to misguide the court or into believing something else. So this is something we should always keep in mind. And you should always, so once you prepare a matter of, or a brief comes to you, you should be very particular with the factual position. Then you should be very particular with the legal position in what is the current law, what are the current judgments. So that is something the court really appreciates. So this is I think what all young lawyers should do. These are just pointers, and maybe their seniors can guide them better. But these, from my end, these are very basic pointers, that how and what a young lawyer should do when you start your journey. So you should develop habits of maybe reading the law, maybe reading the, nowadays we have all these blogs where you can keep yourself updated about every judgment It is not the case that when that people say we'll cross the bridge when we are there. If some case, then we'll read. Should you should make an almanac. You should note down important judgments, or maybe you make a soft copy, note down important judgments. So then you, if some client comes to you, then you can actually you can show your knowledge, and you can help convert the client into a business that you can do. So that is something which I see many lawyers, many young lawyers lack. Also, I would,
We
this is
have uh, we have one question. Which are the softwares that you are using for drafting, or is it just MS Word and the traditional way of?
mostly it is MS Word. It is our entire work is done on MS Word. Yes, MS Word. Research and everything, that's something else, but MS Word we use most of the times. And sometimes Excel, that's not used for drafting, but some tables and something. So MS Word, yeah. Any other questions?
Next up, we have, because since you are an AOR, people are asking how some tips on how to crack the AOR exam, and the opportunity there.
Correct. See, I would be very this thing. So I because I was initially right from the beginning, I I started my journey at Supreme Court, but simultaneously I was also practicing. I was also appearing in trial courts. I was doing a lot of trial court work, and I learned the nuances of basics, at least the basics. I can't call myself an expert, but the basics of trial court work and High Court and Supreme Court. So then I observe the court procedures very closely. So you should. So one thing to start with, as I said earlier, even if you are appearing in Supreme Court or the Registrar Court or the Chamber Judge in Supreme Court, you should always have an open mind. You should know what is a Chamber Judge, where are the powers. So some basic things you should know. So that is something. Why I am starting with this? That is something which really helped me in my initial years when I appeared in small applications in Supreme Court or the Chamber Judge or the Registrar. So I used to understand what I am doing. So that helped me. So what I did initially is I took out all these papers of the previous year's papers. That is, this is the practice I used to follow in my college also. It kind of helps. I took out previous year's papers for 7, 8 years of AOR exams, because what happens is what I understand is I think they have a pool of questions. So they have a pool of questions. So sometimes and many times it is repeated. At times I can't say for sure, but then what I did is I then took out common questions or the subject matter where the questions are repeated, like for 136 or Supreme Court, what is SLP under 136 and the allied rules. So this question is repeated more often in many years in some form or the other. So I noted down. I made a list of those topics. So considering those topics, I read other topics also, but then I was very thorough with these topics which were repeated often again. So that helped me. So basically I did not have that much time. So I made my notes 3 2 3 months ago. I prepared handwritten notes on these particular topics. Rest topics I made short notes or something. I read them. I made short notes on these, and then in the how much time I got, try to manage it. Read it in the morning or sometimes whenever I got time from family and work. Whenever I got time, I prepared, and then I just kept on reading my notes and those questions, and that eventually helped me to crack it in the first attempt itself. So I think smart study. It is not about reading for sitting. It's not an IAS exam for like you have to read 8 hours, 10 hours. So it's about smart study. So like in a practice and procedure, similarly drafting, so you need to actually do some Supreme Court work. Like drafting was easy, not easy I would say, but it because we had drafted SLPs and everything, so we knew the basics. The problem I faced in the drafting paper was that you have to write down the SLP. So we are always used to typing it out. So we always have formats where we just type it out. So sometimes we don't read certain aspects, or we don't read the declaration or the certificate which is in there. So in my AOR exam, you had to read it. You had to know it, what is written in the certificate, and you had to know the language of the certificate. So that was a difficulty. So what I did there was in the second paper, I time myself. So I used to solve the question, because in that question in that paper, you get 30 minutes to read the question paper, and then you get 3 hours. So what you do is you try and read the paper fast, so then you save up 10 or 15 minutes, and then you start writing your paper. So I time myself in reading the paper, and then solving the question. So I have to time myself whether I am able to solve the drafting questions in maybe 15 minutes or 10 minutes. So I used to do that. So that is something which helped me in that. The most difficult paper I would say is the third paper, or the important judgments, leading case laws. That is very tough. They give you around 40 judgments, or all landmark judgments, which you have to read, and you have to know the dissenting judgments and everything. So that is something which is very difficult. I could only hardly read 15, 20 of them. Somehow it only came from those 20, 25 which I read. So that is something which is very difficult, which one should focus on. And the other very important aspect is that that you have to be very careful while writing. You have it it has to be in a neat writing. You have to underline the thing. I understand, because it takes it is the time limit is very short, and then you have to write, but you have to try and be very neat with what you are writing. So that is also very important, because eventually lawyers or senior advocates are reading it. If they don't understand, they won't give you the mark. So you have to be very neat. Even if you have maybe written a short answer, but you are neat about it, they would give you the answer. You've underlined and everything. You put in with black and this thing and underline everything. So those are certain aspects which help. And the most important aspect, you attend the lecture. The Supreme Court, they organize a 4 day lecture, where where the senior advocates come, who have actually drafted. So in that paper you get certain hints. So they just brief you on certain topics. They discuss certain topics. So you have to be very smart and note down which topics they are emphasizing on. At times it comes from those topics, or certain you get certain questions from those topics. So be very smart about it. Certain people think, oh, why should we attend? Because it is usually in June. So people don't attend May or June, I think. So people don't attend those lectures. It is very important to attend those lectures. And I think you have to be very smart about it, about how you go about it. It is smart study, more of not voluminous and this and that and this notes and that classes. You don't have to take any classes for it. Just that you have to have spent some time in Supreme Court. You have to actually know what Supreme Court is and what are the procedures of Supreme Court. If you have done that, I think you've spent a good amount of time in Supreme Court. I think you will be able to crack it. And if you've done some drafting and everything, I'm sure you will be able to crack the
Coming
inquiry.
to drafting, we have a question: which type of fonts are the best for drafting? So, like a basic capsulation for that.
See, basically, in the high courts, all the high courts they use Times New Roman is used most of the high courts. But obviously, it has to be simple. Like we in our office, there is no bar, but the font is you have to use the line spacing, everything that is provided in the high court rules and everything, the indent and this thing. But the font is usually Bookman text, or it is Times New Roman. Most I have seen that. Otherwise, because it should not look very fancy and this thing, it should be very simple. Most of the time, these two fonts are used by my office and others also that I have seen.
So
Yeah.
coming back to how to conduct yourself in the courtroom, often we are accompanied by our clients, and they have to speak up in the court. So how do you brief your client about the norms, or how they have to behave in the court? So that's something very tricky to do. How
No,
have
at
you
times,
handled?
at times we have seen that when you don't, and I've seen in the high court and places that the client tries to argue with the judge. If the judge is saying, "Oh, judge is asking you a question, you've not done this. Where is this?" Or "No, you are wrong." See, the judge will ask, but the client can't answer like that. He has to be very soft, and he has to be very soft in his approach. You have to always, regardless the client knows, if the client is educated, if he's uneducated, whatever the client is, if he's some professor or whatever he is, you have to tell him that, sir, please keep quiet. If the court asks you, then only you argue. then only you open your mouth. If you are not asked to, you will not speak, whatever it be, even if the case is getting dismissed or whatever is happening. And if there is a need which arises, if the client, if you want to speak, you tell me. I will seek the permission of the court, saying that, my lords, my client wants to say something, and then only you will argue, or say anything, address the court. Apart from that, you will not say anything. You have to be very clear. Sometimes, see, young advocates, they don't know all these things. So you have to be very particular when you are taking the client to the court, because your image is also involved. And the court will get back at you. Court will say you are not, court will not maybe not say anything to the client. Court will say, Mr. Counsel, you are not able to manage your client. You have to be very particular. And with regards to conducting yourself in court, it's very important. I just forgot to mention the VC. So what happened in VC, as we all know, certain advocates had appeared in West, and all that was happening in when the it was still new VC. Still we see, even after the Delhi High Court saying, and the court saying, coming up with the SOPs, that you should not appear through mobile phones. That's right. You should not appear through mobile phones. It's because why? There is a certain logic behind it, that you don't appear through mobile phones because the network is not clear. Sometimes there's a problem in the video. Sometimes you're not audible, and the court has so much work. At least they are giving you this facility. You appear from your office, you appear from the chamber, from your laptop, go to some place with a neutral background, but don't use your mobile phone. I've still seen people not using, still using mobile phones and sitting in cars, which is clearly banned in the High Court. SOP says so, that you have to be in a place with a clear background, everything. And experienced lawyers also, not even young, experienced lawyers also. So we need to be very careful about this. At times, if you are outside, or you can have somebody up here, but you should avoid. One should avoid this. It does not look good as a counsel. You should always make sure that you always follow the rules of the court. So this is about it. And yes, about the client, that we are always responsible. We should not forget that we are responsible. We are an office. That's why the court always calls us the officer of the court. We are first and foremost the officer of the court, and then something else, and then the client and everything represent. First, we are responsible to the court, and then to the client. So to be very wary of the fact, you have to understand this. All everybody needs to understand this. So this is very important. Yeah.
So video call thing brings me to the body language that we use in the courtrooms. So I have often seen that the clients or the younger interns that are with the advocates face their backs towards the bench, and
That's
some of the judges take it as an offense. So some points on those lines.
That's why I earlier mentioned that you have to stand, even if you're intern, you have to stand upright. You have to not stand on the dais. Like your senior will stand on the dais, you will just stand by the corner. You can't be, maybe you can't, no, you cannot be assisting your senior. According to me, you cannot be assisting your senior because you're still an intern. So you can maybe in the office, you can prepare the notes, you can stand by the corner, his junior will stand by him, or you could stand and maybe from there you can pass a note or something. You can stand sideways facing the court and then leave, but you can't put your back to the court. And at times, see, at times I've seen in councils also, at times, see, it is depending on the mood of the judge. See, at times, certain judges, see, certain advocates, they use hand gestures. So sometimes you have to be very sure, if the court is saying something, you can't do like this. You can't say, wait, 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 I will tell you. You can't use, you can use hand gestures while expressing like this, but you can't do like this. That you wait, I am telling you, wait, you can't do like this. So I've seen in the Delhi High Court, in the recent past, I've seen there was a counsel who was arguing. He was arguing very well, but the court asked something and somehow he showed his hand or something. I don't know. The judge got very annoyed and he bashed him like hell. So it was very difficult. So to be very careful, even if you're using hand gestures, and not to get very excited and all that. Even if you have a good case. And then one very important thing which I gathered from my own experience. See, as a counsel, I argue my matter. Even if it's a weak case, it's a strong case, doesn't have to be. I will argue the matter. But the as a counsel, you should be fearless. Respect is something else. You should respect the court. You should not shout. You should not raise your voice. But then you should be firm as a counsel. You should argue your matter. Even if the judge is trying to put you down, saying, no, no, you withdraw this, then you slight, put it in that manner that my laws may pass an order on merits. I will take an order. But that at times, see, this comes with time. Initially, I also did not know it. So at times, there was incidences where the judge shouted, "No, this is not the way you talk, and this is not the way you argue or raise your voice." So I am a bit aggressive in my argument style. But then I understood that this is not the way. But one or twice, 2 times it backfired on me in my initial years, in my first and second year. Then I understood that you have to always be very soft. You have to be aggressive in your approach. You take an order. You don't give in to the court. That if the court is pressurizing you, at times the judges do it. Like if they don't want to pass an order, if they think there's a certain this thing, they try to pressurize you to withdrawing it. But you should not withdraw. You have to understand. Then the client can't go in appeal. So you have to stay. You have to hold your ground, argue your matter, and take a order on merits. But there is a manner of doing it. Not to raise your voice, not to shout and go crazy about it, not to bang this thing, the dais and everything. So you have to be very smooth with it. So that is also my suggestion to young counsels. You have to be very quick, and you have to be very quick in your response to court. You have to see where the argument is going. You have to see where the court is taking you in the argument. You have to see what you have to say, and you have to have one very important aspect I did not cover. Yeah, you have to also, while arguing, you have to know when to keep quiet. If the and this is very important. If the and I have actually won big matters because of this. If the court is on your side, you keep quiet. You don't argue. At times, you can spoil your matter by arguing if the court is on your side, and the judge will tell you, counsel, you don't need to argue when we are on your side. So at times, you get excited. Oh, I want to say this. I prepared my matter. You don't have to be excited about it. You make your case, and if the court is on your side and showing this thing that they are showing your inclination towards giving relief to your client, then you have to keep quiet. You will win the case. So it is not, arguments are not only won by arguing the matter. You can win the arguments by keeping quiet also. This is especially for young lawyers. They think they want to say everything in court. And day before yesterday in Delhi High Court, I saw there was a counsel, young counsel, fairly young counsel. He was arguing, and then he sort of gave some kind of undertaking, and the judge then noted his this thing that he is giving some undertaking in some injunction matter. He gave his undertaking when the court was already not doing it. But he said, no, 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 we will not do it. Court said, okay, we will note your argument that you said that you will not do it. So sometimes speaking more is dangerous for your
Absolutely.
case. That is all.
Exactly.
Yes.
Right. So one question here is, can you also aware us about seeking Passover and
Yes.
adjournments?
Yes, so that is also, see, there was one book of Ali Nariman. So I read that book once
Mm-hmm.
when I before memory fades. So when I started, even I think before I started practicing, I read that book. So that's it. That book is whole encyclopedia in itself. On whatever I'm saying is there in that book. So because I learned it from there, from Mr.
Oh,
Nariman itself by reading that book. So it mentions very clearly that one fact. It mentions that once you are given a brief, so like people don't understand, yeah, especially young lawyers. We also have juniors. Sometimes they don't understand. They say, sir has just given for Passover. If I have given you a brief, you have to read the brief. The senior will not always tell you what to do. You have to read the brief, even if it is a Passover. And I have seen in Supreme Court, even if it's a Passover, and you go, sometimes the judge says, okay, you argue your matter. What is the fact? At least you should know the facts. And you should maybe, I think every file you should read. So when I started my practice, I made sure ever I am given a file, I always read a file. Even today, if my any of my friends tell me that, oh, you please take a Passover for me, I'm late. I say, you please give me the file, or at least I ask him what is the matter. So if the court asks, I can tell. I said, give me something, give me some orders or something, so I can tell the court what had happened, what is the matter, briefly. So that is very important that you do that, and you always carry the file. At least in your younger age, you always carry your file. If you are taking a passport, you don't. I saw in Supreme Court one of the councils used to carry a file young lady, she just went pass over. You don't say pass over. How what will the judge will know? You say, my laws may kindly pass over the matter. You just don't stand there and say pass over. You have to be kind of there's a way of taking a pass over also. And in certain high courts,
Exactly.
it's called it's like in Nainital High Court and Allahabad High Court, it's called a revised list. So then you have to know that fact. Once you are going to a different high court, you don't say pass over. You have to understand there it is called revise. So there we say, my lords may revise the matter or put it in revised list. So there is a way of asking of a passover in every court. So you have to, when you go to a court, you have to understand the ways. So if we say passover in Supreme Court, so in some other high court, it's not called passover, it's called revise. So you have to be also you have to also understand that fact. So that is always, you have to always an adjournment also, you have to understand. The other day I saw, see, we all had a good laugh in that. The other day the council junior was appearing and he said, my lords, today the council is in some personal difficulty. Yes, what is the difficulty? He says, sir, today it's his birthday. What is this? Okay. I don't know. That was so. We had a good laugh. I was actually laughing at what kind of this is. You say something else. Say he's indisposed. He's busy in some personal matter. You don't say it's his birthday. So if somebody's expired in the family, you tell, oh, my lord, somebody is expired. That is some reason which you should tell the court. Should not tell everything to the court. So that is what young lawyers should understand. That and then one another mistake what young lawyers do is they say my senior counsel. You don't say my senior counsel. You say the arguing counsel. Even if the trial court, you say my senior or the arguing counsel is busy, and what they do is they say the senior advocate is busy in high court, so the court will think some senior advocate is coming to argue the matter. So they say the senior advocate is coming or my senior advocate is busy in some. So you should say the arguing counsel is indisposed or he is busy, or you have to understand. So that is something very this thing. This all this I have seen in trial courts happening. So that is something I see which the lawyers, which young lawyers don't understand. And if these small things you inculcate as a practice, it will eventually help you develop as a counsel, as a good counsel. Any other questions?
So,
Yes, sir.
yeah, carry on, Hina.
Yeah. Actually, I want to ask, then sometimes judge is when judge is giving the order, it's not sometimes hearable, like you could hear it. So how we can get to it? Whether kya order what order is
See,
there?
at times, see, in Supreme Court and High Court, it's always it comes by the evening. So, so at times, if it is like that, we can ask my lords may tell the last part, or my lords may pardon, my lords, I did not hear it. You say it.
Yeah.
In trial courts, you can ask the judge. Trial court is little bit more casual. You can ask my lords what was the last part. You can say it. You can ask the judge, and or even you can ask the court master. You can go and ask what is the order in this, or you can just give it in writing that kindly tell this. And acha, one more way, because the time is running short, I will cover one more aspect which is not part of this thing, because I was hiring for past few days. So that's also one very important aspect which I saw. Nowadays, what is happening that young lawyers, even freshers who have 1 year of experience, no, maybe 4 months, even they've just passed out. When you ask them for salary, they say 35,000, 40,000. They don't understand. I understand if it's a law firm, you
If
can ask
yeah,
for that. Maybe they will give. But once you are going for independent counsels and a chamber practice, what see in any culture you see, in any culture, in any field, they always pay for skills. They always pay for skills. If you are skilled, then I should pay. And I understand national, non-national is irrelevant now, because I belong to a non-national law college. I'm still doing okay for myself. So national, non-national does not matter. But what you bring to the table is important. You have no experience at all. You are asking for 40,000. This is also young guys need to understand. There was one I not there was one particular she was practicing for 1 year, one particular candidate. She had not drafted a single SLP, single thing, and she was expecting 35,000. I did not tell her, but I told her that you should be reasonable, should understand that you always should that do you deserve this? Do you actually deserve 35,000 for what? Do you have the appropriate skills? I and see, as employers, we don't mind if somebody has 2 years of experience, 3 years, and he's actually done his part. He has drafted 100 SLPs, 20 writ petitions. I don't mind paying for paying the bills. I don't mind paying, but should always understand that you should have that kind of experience before you go and ask for that kind of money. These, I don't know, these youngsters don't understand. They think okay, we should be paid. I understand one should be paid. That's hands down, that everybody should be paid for hard work. Once if somebody's joining some, even if it's an intern, he should be also paid some stipend by the senior. Whatever work we are giving him, something should be paid. At least a travel allowance or something, independent depending on every lawyer. But then candidates should understand for because
They
every
should
time
have
we
the right skills. So I think this is the right point where I can pitch LawSikho, that people
yes
can actually learn skills here, and
yes
they are
yeah
expecting that you at least
you
invest
acquire
in
those
yourself
skills.
first. Yeah.
You acquire, yes, you should raise a question. And I actually, to one or two of the candidates, I told them, do you understand that you can just come and say, sir, 40,000, but what is there in your CV for 40,000 rupees, which I should actually think I should pay you 40,000, and I will give you, if you work with me, I will give you that 40,000 in 1 month only, even in 1 month. If you actually do that work, if I think you deserve 40,000, I'll give you that 40 right away in 1 month. But I will not, to begin with, I will not give you 40 because you don't have the relevant experience. So
And
that
that's
is
what
something.
LawSikho is actually doing. Like they are
Yeah.
giving practical courses. They are telling people to draft even before they have, passed out from their
Yes.
colleges.
Yes.
That
Yes.
you do a lot of drafting yourself and take review on that. So at least when you go to the employer, you can tell that, boss, I
Yes.
have done
Yes.
these draftings. I know it
Exactly.
how to do it. So
Exactly.
then maybe they can
Exactly. And
negotiate better
actually,
with you.
I I actually hired one or two associates earlier, past 2 years back. I from your reference, you guys gave some reference, and I hire. They gave their drafting samples, and then they came and they turned out to be well, and they were fine. But they see in our profession, eventually they grow out. When they learn, everybody goes. So I actually hired from that. So that is one way of doing it. But then this is something which the young lawyer should learn, because see, then if see, and this is a very important aspect why I would say, see, if I, as an employer, if I have a salary bracket in mind, maybe I am paying 20. If you say 20 is my salary figure, if imaginary figure 20, and the other guy comes in and say I want 50, so there is no bargaining ground. I can't. There is, so the gap is so wide. We can't bargain, and we can't ask. Even if I am liking something about that fresher, and I think that this guy can work or this girl can work, but then if you put in a figure to it that I want this or I am expecting this, so you should always not put a figure when you don't have the experience. Even if you have it, should not put a figure, because that holds back your a lot of opportunities, because then that that his interview is over right there for me. If that guy has quoted some skyrocket figure, so that's over. That interview is over right there. I would not go further with that. So that is something which the young lawyer should understand when they go for an interview, even while drafting their CVs, not to put in false things. Like one girl had drafted one SLP, she'd put SLPs, drafted SLPs. I asked her how many, she said two. That also with my boss. So I said, so that's not even one. So this is something yeah, always they should keep in mind. So
Okay,
this
keeping
is
the time in mind, let's just take one last question
yeah,
from the
I'm looking
audience.
for yeah.
Mayuri is asking that in the like when you start your practice, how do you get the recognition and build clients, and continuously maintain the practice?
See, this it's a whole exercise, because see, I will again go into that. I will go take. I will take 2 minutes in this, because this will need some explanation, because this is a whole this thing, and every day this question comes to me. See,
Completely fine.
there is a whole debate about, I will have to get there. There is a whole debate about people with law background, people who have families, and then people who are first generation lawyers. I understand. See, like I belong to a family of lawyers. My father is a senior advocate. My grandfather was a senior advocate, but they are all in Uttarakhand. I came here. I built my entire practice here. I did lot of freelancing work. I kept running around, going to trial courts, going to, I don't know, police stations, everywhere. So if I would have been there with my father's chamber, it would have been very easy for me. It would have been a cakewalk. I would just sit there. There also, you need to understand. If I am not a hard worker, so there also I would have failed. So if you don't have the skills in you, don't have the aptitude, father or no father, does not matter. Any generation, 5 generation you give, if the person, he or she does not have the skills, does not matter. So eventually, end of it, what kind of person you are, if you are a hard worker, if you actually work hard, that will matter. So I built my entire practice from scratch here in Delhi and coach around Delhi and Supreme Court. I built my entire practice here, and now and so that is one thing. And see, I faced a lot of problems in trial court. So initially, what I did is I worked with few advocates on freelancing basis. I followed a different approach. I joined a law firm for 6 months. Then I joined a senior advocate for another 2, 3, 4 months. Then in the meanwhile, I started going to another advocate. He had a lot of trial court work. He started giving me some trial court work. I sometimes I used to get paid, sometimes I did not used to get paid, but I did not care. I always used to go around running. So then I used to get orders and orders for him. Then those clients got to me, and then because that advocate did not take up those matters, never used to appear in those matters. Only I used to appear. So eventually, when their matter got over, the clients those clients which were his, they referred matters to me. So that was whole chain of this thing. And then you have to also for young lawyers, you have to understand that after you have to gain knowledge. What happens is nowadays everyone, like young lawyers also, they just want to अरे पैसा कमाना है हमको बहुत सारा, और they go crazy about getting money. See, money will come running after, but you have to build yourself, your knowledge. First you have to have the knowledge. You have to know the process. आपको पता तो होना चाहिए ट्रायल कोर्ट में होता क्या है, व्हाट इज द प्रोसेस फी, व्हाट इज दिस, हाउ टू अप्लाई फॉर सर्टिफाइड कॉपी. You should know everything. Another aspect is that nowadays, I will come to this also. Nowadays, many young lawyers, they think, oh, हम clerk का काम थोड़ी करेंगे, this is clerical work, why should we go to the registry? And many people think this, and I have heard people saying this, कि उस ऑफिस में तो और registry में भेजते थे. अरे, you are learning. I have myself done that. Initially, in my first year, I did not have a clerk. Obviously, इतनी फीस नहीं मिलती थी, क्लर्क कहाँ से आएगा? Used to keep running around in the registry, get matters listed, get this thing, applications filed, everything we're doing on our own. ट्रायल कोर्ट की फाइल में कितने कॉपीज लगेंगे, क्या होंगे, एवरीथिंग यू हैव टू लर्न. परफॉर्मा कैसे भरा जाएगा हाई कोर्ट में, व्हाट परफॉर्मा इज देयर. सो ऑल
वर्क
दिस
कैसे
व्हेन
करना
यू
है, एवरीथिंग, पीएफ
व्हेन यू
कैसे करना है. Yeah.
हाँ, when you actually learn this, then you नंबरिंग कैसे करनी है फाइल की, तो यू हैव टू फर्स्ट डेवलप. दिस इज द फर्स्ट स्टेप. आप डायरेक्टली वो जो सूट्स वाले लॉयर नहीं बन जाओगे, या वो नहीं बन जाओगे ऐसे बड़े लॉयर जो उसमें दिखाते थी. ऑल दैट इज ऑल दैट फैंसी. इट इज ऑल फैंसी. सो
Yes.
वो होता है कि आजकल के बच्चे, दे आर सीइंग ऑल दैट, दे थिंक कि बस पहले दिन ही हम कॉर्पोरेट लॉयर और बिल्कुल टॉप गन बन जाए. दैट इज नॉट देयर. So you should first develop yourself, first develop the knowledge base, and then work on it. Once you are there, when you have the knowledge, and if you have the knowledge, it will show in court. You will start getting orders, and you will start winning cases. Then you always, time to time, you have to do your self assessment. Even I did a course from LawSikho. I did this EABL and UJS EABL course. I did in 2016. You have to always keep updating your knowledge, because I thought, because that at that point of time, lot of startups were coming in, and I had less knowledge about business law. So I had to learn these things, because I was meeting people and I did not have that knowledge how to start a company and this and that. So I did a course. I updated myself. Now I can talk to a person if somebody comes in that, oh, I want to start a company. I can tell him basics. I'm not a CA. I can't tell him everything, but I can tell him basics, that you can do this. You can, at least I can talk to that guy. So you should always keep developing, and we are all learners in law. So if you do these 1, 2, 3 points, if you working hard, there is no leeway around working hard. There is no shortcut to success. You have to understand there is no shortcut to success. Nowadays, what students are doing, they're filing PILs. So Supreme Court and High Court has said that these are just publicity interests. You you have to understand. I have also filed many PILs, and I in 2000, 2016, 15, 16, 15 or 16, 4 years down the practice, I got a reported judgment by filing a PIL. Not in my name. I was the counsel, but I filed a pro bono PIL. I got a reported judgment because I know what I was doing. I did not just file it for the sake of publicity. So that way you have to understand that this is not going to help you. That file some PIL something, oh हमारा नाम आएगा live law में, does not matter. उससे कुछ नहीं है. That's what Supreme Court said, that nowadays interns are doing this as an internship project. So you need to understand that you have to work hard. ये publicity, obviously when it is a right time you will get the publicity, and when after a certain point in your career you have to be very, our profession is very social. You have to be very social. You have to talk to everybody around. You have to talk to clerks. You have to be very humble with everybody. You have to talk to your juniors. You have to talk to your college alumni and everybody. You never know who can give you work. So that is something for maybe a first generation or a third or a fourth or any generation lawyer. You have to keep socializing. You can't be anti-social and not talk to people and expect people to give you work. So you have to be good with people, not fake, not fake around, but then be genuinely good with people.
Yeah,
Talk
at
to,
least do what you can do.
yes, do what you can do. You help people. See, and if clients come to me, they say, "Ki sir, we don't have money." I help them. I said, "It's okay." I don't say, "No, no, मैं तो इतनी फीस लेता हूँ, नहीं है तो जाओ भागो यहाँ से." So I help them. I always help them where I can. Or I tell them that I'll give this case to my junior. I will guide him. She will fight it out. If you have the fees, you pay. If you don't have, it's okay. So I do take up pro bono matter. But there are many lawyers who don't work without the money on the file. They say, "Pehle paisa, then we'll talk." And nowadays, people, and I have seen people asking for, young lawyers asking for 1 lakh, 2 lakh rupee fees. On what basis? Again, on what basis? You have to understand money will come after. If you are working hard, if you are doing the right things, if you are not, see, end of the day, you are answerable to yourself. So you have to always justify yourself and not your friend or somebody else or somebody else. You have to justify yourself that yes, what I am doing is the right thing and I am learning. You have to always keep testing and asking yourself this question: am I on the right path? Am I doing the right things? And there is no right formula for becoming a successful lawyer. Everybody has their own ways. But then you should follow some principles. You should have some principles, not cheating the client, not duping the client. If somebody is giving you a brief, if you don't know, if you can't file, tell them you can't file. If you can file it, if you've given him a date, you tell him. If you've taken up a matter, you appear. And even if you can't appear, you tell him, "Ki, sorry, today I'm busy, I'll send somebody else." But don't mistreat your client, don't talk badly to your clients and all that. So these things, if you are doing these things, then I'm sure people will like your work. People will like you for what you are. Like one of the, like in my experience, in many lawyers, even in my, with my experience what I have, lawyers don't tell the client what they're going to do. So many clients come to, they say, "Sir, वो कुछ बताते ही नहीं थे, हम बोलते थे, वो बोलते थे हाँ
Exactly.
कागज करो जाओ, कागज साइन करो जाओ." So they never used to tell. He says, "I take." So sometimes it takes a lot of time. So I take 30 minutes with the client, regardless whatever he has paid me. Maybe he paid me 10,000, 5,000, 12,000, but I give appropriate amount of time to that client. I tell him the process. See, I can't tell him my arguments and everything, but I tell him we are going to file this application. This is what is going to happen. We are taking your signatures. Like this, you have to explain something. Then the client are very happy at times. They say, "Oh sir, we hired such a senior lawyer, way experienced than you, but he did not tell us a single thing. And he just did, a matter got dismissed. Gave us the file. Oh, you go to Supreme Court. Now your case is dismissed." But when you are explaining, it is easier for us to understand. Now, even if the court dismisses our SLP, it's okay. But at least we understand what you are saying and what is happening in the matter. So it's one thing is communication to your colleagues, to your everything. Communication is very important, which actually helps. And then being fair with the client, that is something. These are certain things which if you do these things, so it would help you. It would actually help. So these things have actually helped me. and it does. And then talking, and then another aspect, talking humbly with your staff, your clerks. Sometimes the lawyer, they just shrug away their clerks and this thing. And even there was one candidate who told me his boss abuses him. He says he wants to leave the office, that the boss abuses him. I said, oh my god. I said, what is happening? I don't know what is
This.
happening. So sometimes the seniors also need to take a note. You can't do this. Everybody is human. You can't do this to somebody. You can't abuse. Whatever that of you throw him out. You tell him that I'm terminating your employment. That's all. That you can't abuse. So some things are for everybody. Everybody needs to understand. So you need to pay your juniors on. Some guy came up. He said, oh, for 3 months I did not get my salary. So seniors also need to understand. You need to
And
pay.
many good lawyers, the senior lawyers are doing like this. Yeah.
Yes, so it's for everybody. So you need to pay, you need to be very humble, and you need to work hard, and that's it. I think that's it. And there is no correct formula to getting clients. And then if you are working, it's all connected. If you're working hard, you will get work. If you get work, then you'll perform well. If you perform well, you'll get the clients, and the clients you will retain, and they will refer. It's more of a word of mouth thing, referral thing.
Yes.
Apart from this, one more this thing, that see, everybody can't write, but writing, if you should share your views on certain this thing, like I share on LinkedIn and Facebook. You should write. You should go out there and write if you can write, and if you think you can write, you should try your hand at writing, blogging on subject matter. So certain people read also. So it's an indirect PR. Certain people read that and they think, oh, this lawyer has this knowledge. Somebody might approach you. So that ways you can also do that. So that's something also you can do. So that is about it. You like live law, bar and bench. You can write articles and show your knowledge. That also again you can only write when you have the knowledge. So then they should have the knowledge. So knowledge is very important. If you have the knowledge, you can beat anybody. You can beat all the top senior advocates, and you can beat. And this I have experience of beating good counsels. I have done it, and that's why I can say that if you acquire certain level of knowledge, you can do. Nothing is impossible. Nothing is inachievable. You can achieve anything. So that is my
Amazing tips, sir. Amazing tips. I
Amazing.
guess
Exactly.
all of us enjoyed and take down the notes that you have given
Learned
us.
a lot.
Yeah. Thank you so much for joining us at the YouTube live with LawSikho. And it was a pleasure to host you and get the notes from you. And I'm sure the audience would have also enjoyed it. Thank you so very
Yes.
much.
Thank you for having me. Thank you, Hina. Thank you, Rudresh. Thank you.
Thank you, Mr. Ayush. Thank you.
Good night. Good
So
night, everyone.
one, yes, so one
Yeah, yeah, tell
last
me.
thing. For the audience, I have one announcement that just like online events, we are also organizing meetups. LawSikho is organizing meetups every Friday. There will be meetups on legal topics at Das Circle, Huda City Center, metro station. So it will be on every Friday. You can join us for these legal meetups and build up your networking with the lawyers like Mr. Ayush Negi, right? So do join us. I request Mr. Rudresh to share the link, right?
I have already
It's
shared
in
the
the
link.
chat.
Tomorrow we are having an event on how you can become a CEO in a tech company, being a lawyer. Like what are the upper hands you have as a lawyer to become a CEO in a tech company. So would request all of the interested people to just join us there. I've shared the link in the comments and would like to and love to see you there and network with all of you.
Okay.
Good night. Good night, everybody.
Good night.
Good
Good night.
night.
Thank you so much. Yeah.
Thank you, everyone. Thank you so much.